His office attracts the best people. It is an important office. It is a challenging office. The opportunities in his office to do something important are unlimited. Our guest today has moved his office to the forefront in the nation in the areas of domestic violence, combating juvenile crime, and dealing firmly with hate crimes. Our guest today was born and raised on the North Side, where he still resides. He and his wife, Shar, have 4 children and 2 grandchildren. He was a student athlete, an outstanding athlete, I might add, at Loyola Academy, and graduated cum laude from both Loyola University and the Northwestern University School of Law. He was managing editor of the Northwestern University Law Review. Ladies and gentlemen, it gives me great pleasure to welcome back to the City Club of Chicago the State's Attorney of Cook County, Dick Devine. Richard?
Thank you. Thanks so much, Jay, and I want to echo what Dr. Green said about how important Jay is to our community. The City Club is a forum where we hear many speakers with covering topics of current importance, and Jay is largely responsible for that. I also want to acknowledge the presence of someone very important in my life, and she's going to be important to you, too, for a reason I will tell you, my wife, Shar, who is with us today. The reason she is important to you is that after 18 minutes, she will start clapping. And if I say I'm not finished, she will say, yes, you are. So, and there is a very important group that I do want to acknowledge. We have done many things in the last 5 years that are important. And it's thanks to the leadership in the office and the assistant state's attorneys who work so very hard, and our investigators. So please join me. There are many of them are here, and I'd like to just have a round of applause for the great people in our office. Walter Burns relates the following story in his book on capital punishment. In the dark of a wild night, a ship strikes a rock and sinks, but one of its sailors clings desperately to a piece of wreckage and is eventually cast up exhausted on an unknown and deserted beach. In the morning, he struggles to his feet and, rubbing his salt-encrusted eyes, looks around to learn where he is. The only human thing he sees is a gallows. Thank God, he exclaims, civilization. Some of us laugh, but many of us are troubled by the image of a gallows representing so-called progress. Isn't this the 21st century? Aren't we better than that? Then we recall Nazi Germany, Stalinist Russia, and in more recent times, Kosovo, the Middle East, Rwanda, and finally September 11th. And then we wonder, how far have we really come? We think that perhaps human nature is human nature, and no matter how far we have advanced technologically, society still needs to protect itself from the worst of us. At some point, we must all face the question of how we do that and whether we will, as a community, use the ultimate punishment against a fellow human. When I think of the death penalty, I think of 2 people. The first is Hernando Williams. Hernando Williams was on bail pending trial for the rape and kidnapping of an Evergreen Park woman. Then he kidnapped 29-year-old Linda Goldstone, who was on her way to teach Lamaze classes just a few blocks from here at Northwestern Hospital. Hernando Williams locked Mrs. Goldstone in the trunk of his car for 2 days. He periodically took her out to beat and rape her. After the first night of Mrs. Goldstone's ordeal, Hernando Williams reported to the Maywood Courthouse for a status hearing on his pending rape charge. While Williams was at the courthouse, he took a break. He returned to the parking lot, opened the car trunk, and checked to be sure that Mrs. Goldstone was still there. On the second day, Linda Goldstone escaped and ran half-dressed to homes where she banged on the doors and begged for help. Hernando Williams pursued her and shot her to death. Hernando Williams later told police that he shot Mrs. Goldstone because she decided to run for help. Hernando Williams was executed for his crime, and there has never been any doubt about his guilt, even though his case included a confession that he refused to sign. Police followed all leads and developed overwhelming corroboration for Williams' confession. Police and prosecutors achieved certainty concerning Hernando Williams' guilt, and in my view, we served justice by imposing the death penalty. Every violent felon faces a potential penitentiary sentence when he commits a rape, armed robbery, or kidnapping. When a felon like Hernando Williams weighs the victim's life against the penitentiary, the law must give him a reason to value the victim's life as much as his own freedom. And this will only happen if the defendant knows that he puts his own life in jeopardy when he kills his victim. Hernando Williams and others like him, such as John Wayne Gacy, are strong arguments for the death penalty. But the other person I think of is Anthony Porter. The system did not work in his case. He was close to execution, too close. Anthony Porter was convicted of murdering 2 people in Washington Park. Anthony Porter was at the murder scene. He did have a gun at the murder scene, and witnesses correctly identified him as being there. The truth also is Anthony Porter lied about being in Washington Park, and he lied because he needed an alibi for the armed robbery that he had committed during the murder just a few feet away from the scene of the murder. Anthony Porter was tried and convicted because police and prosecutors truly believed they had sufficient evidence to convict him. Because of that, they did not follow other leads, including those which pointed to another suspect, L. Story Simon, who confessed to the murder while Anthony Porter was on death row. The case of Anthony Porter was a wake-up call for all of us, a caution that we have to look very closely at our justice system, especially in death penalty cases. In the last few years, there has been a serious and far-reaching debate about many aspects of the death penalty. I personally believe that the death penalty is an appropriate punishment in certain cases. Some people's acts are so cruel and so threatening to their fellow man that no other punishment is appropriate. But we don't have a death penalty because of my personal beliefs or those of other prosecutors. It is the law of the state of Illinois, debated and passed by the Illinois legislature and approved by the governor. As prosecutors, we have no greater responsibility than our role in the administration of the death penalty. Because of Porter and other cases, we know that our system must be improved. In fact, it has been improved dramatically over the last several years, both at the initiative of the Illinois Supreme Court and a number of prosecutors who believed that reform was necessary. Recently, we received the report on the Governor's Commission on Capital Punishment. Most of you, I'm sure, are aware of it. It includes 85 recommendations to include the state's death penalty procedures. And over the past few weeks, I, along with the top people in our office, have been reviewing it. I have also been meeting with the Illinois State's Attorneys Associations, which represents the 102 state's attorneys who hold office across the state. Several of them are with us today, and they have been introduced to you, and I want to thank them for the outstanding work that they do on a regular basis to make our criminal justice system work. My fellow prosecutors and I have gone over every recommendation in the report, and today I'm speaking to you not only as the State's Attorney of Cook County, but also as President of the State's Attorneys Association. We are united in our commitment that the system must be improved. Human beings make mistakes, but when it comes to capital cases, the system must keep mistakes from getting through. We must know to a moral certainty that we are holding the right person accountable. In our review, we found that we agreed with the vast majority of the Commission's recommendations. In particular, we wholeheartedly endorse the Commission's call for expanded DNA testing. In fact, I called for this improvement many months ago in my submission to the Commission. DNA is an effective, objective tool, one of the best tools that the justice system has. It has spared the innocent and confirmed the guilt of violent criminals. Yet, like many other states, Illinois has a substantial backlog of samples waiting to be tested. Forensic lab officials say their turnaround time for DNA testing is now at least 6 months. We realize, and I'm sure the Commission realizes, that adequate testing means additional expense. But all we need to do is look at the millions in settlement dollars paid out in civil cases brought by exonerated defendants to see the value of early testing. And add to that the cost of devastating crimes that could have been prevented had the right defendant been identified as early as possible. Today, we ask the legislature to act quickly. We need to end the backlog and to ensure that there is full and early DNA testing done in every case where it is applicable. We know there are budget shortages, but this is crucial. It's hard to put a price on the safety of our people or on justice. We also support the Commission's call for additional training for prosecutors, defense attorneys, and court judges in capital cases. We supported the creation of a capital litigation bar from the start, and in Cook County, we're already participating in it. We agree that precautions must be put in place to test statements from those we refer to as jailhouse snitches. In those areas and many others, we strongly back the Governor's Commission. Its members spent 2 years studying the death penalty process, and we respect their work. The Governor, as you know, has now submitted the package to the state legislature, and while we have not had an opportunity as an association, nor have others, to present to the Governor our recommendations and our responses, we are responding to each and every one of the 85 recommendations and will fully participate in the legislative process as it goes forward. In a few areas, though, we believe further analysis and study is required. The Commission recommends, for instance, that police interrogations in murder cases be videotaped from start to finish. Many of you know that our office already videotapes murder confessions. We began that back in 1999, long before the Commission's report and without any law that required it. Although there was some reluctance at first, it has worked well. Since 1999, we've taped well over 500 confessions. The tape shows suspects talking freely about their crimes and strongly supports the voluntariness of their statements. These tapes have proved to be strong law enforcement tools. We make these tapes when our assistant state's attorneys are called by the police to take the statement. Generally, that's after police interrogations are finished and the defendant has already admitted the crime to detectives and has agreed to give a statement. Expanding the taping process to the entire interrogation raises a new set of questions. On the one hand, taping the whole process has some obvious benefits for law enforcement. Tapes can confirm how often suspects freely confess without coercion. They can also disprove false allegations of police brutality. At the same time, there are issues, real issues. In some cases, a defendant is brought to the police station as a witness rather than a suspect. If that man then implicates himself, can there be problems if the interview hasn't been videotaped? How would hearings on motions to suppress evidence and statements and trials be affected? Would judges and juries have to sit through hour after hour of videotapes? What if a suspect has prior convictions or failed a lie detector test? Those facts often come up during interrogations, but are never allowed at trial. The tapes obviously would have to be edited. Jurors would naturally wonder what part of the tape was missing and why. Instructions to the jury would have to be developed to protect both sides against being blamed for editing out part of the tape. What if the camera malfunctions? Would judges then be required to throw out the confessions? And perhaps most importantly, what if a suspect is intimidated by the camera? What if a murderer says nothing when he would have otherwise admitted to his crime? In response to that last concern, the Governor's Commission has recommended that the Illinois Eavesdropping Act be amended to allow suspects to be questioned without knowing that they're being taped. We believe that recommendation is crucial and should be adopted. Unlike DNA testing, creating the exception to the Eavesdropping Act costs us nothing. We're asking our legislatures to pass it promptly. Once that law is in place, that exception, The Illinois State's Attorneys Association proposes, as I have proposed in the past, that we establish pilot projects to develop protocols for videotaping interrogations. To support the pilot projects, we recommend that the legislature create a fund that would assist police departments to acquire equipment, hire personnel, and find storage space for tapes. We are prepared to work with the legislature and our police departments to develop guidelines for this program. As an aside, in 1999, when our office began to videotape murder confessions, we invested in 10 portable video systems, along with editing equipment, microphones, and playback systems for the criminal courtrooms. We also provided training to certify court reporters as videographers. Our total cost came to about $160,000. The important point is to get started in a controlled, reasonable way, in a way which allows us to identify and handle the practical problems which will inevitably arise. If we proceed responsibly, we can build a solid system. If we rush in, I fear we will gain a headline, but harm justice. I want to point out the role that we as prosecutors feel that we are obligated to undertake. There are many points of discussion that go around, and it is understandable that the public thinks that they make easy sense when they are just talked about generally. But we who are in the system, along with the police officials who know the problems that can arise from developing programs, have a responsibility to speak out and to talk about doing this in a way that allows us to see what the real issues can be so that we make this successful and not just something that is thrown out there and has a life period of a little bit and does nothing but harm the criminal justice process, which, after all, we all hope is a truth-seeking process, not a process that we look to establish more and more rules just for the sake of making it look like we have a better system, when in fact all we are doing is making the system more complicated and preventing a verifiable and correct truth-seeking process. I'm hoping that through these pilot programs, which I have recommended, that we can address the various legal and practical concerns that have been outlined. We can also react to unexpected problems as they arise. And hopefully we can establish a system that all of us, including the police, can live with. In a few areas, we find that we simply disagree with the Commission. As many of you know, the Illinois death penalty law was rewritten in 1977 after the United States Supreme Court declared earlier laws to be inconsistent and unconstitutional. Illinois responded with classifications that made a convicted murder eligible for capital punishment. At first, there were 7 eligibility factors, but over the years, the number has grown. We now have 20. The Commission found that the eligibility factors now, in effect, sweep too broadly. We agree. In fact, we feel the factors could probably be cut in half. The Commission, though, has recommended that only 5 remain. Those are murder of a police officer or firefighter, murder at a correctional institute, a murder that obstructs the system of justice, such as the killing of a witness, the murder of 2 or more people, and a murder involving torture. The Commission members note that the law must single out the most heinous and shocking homicides for the ultimate penalty. Yet we feel they inexplicably left out some of the most shocking and heinous crimes when they came up with their categories. They eliminated the eligibility factor that allows the death penalty for an exceptionally brutal and heinous murder of a child under 12. They have also ruled out murder that is committed during a forcible felony, which would include not only armed robbery murders, but also rape murders. What is more shocking and heinous than the brutal, deliberate murder of an infant child, or the vicious rape and murder of a woman? And what type of criminal poses more danger than a serial rapist or a child killer? Several years ago, a man from Cook County broke into a home armed with a knife. He raped and sodomized a woman and murdered the woman's 6-year-old son. He split the child's throat from ear to ear. He was tried, convicted, and executed in 1995. Today, another Cook County man sits on death row. He repeatedly punched a 16-month-old girl. The child's liver was lacerated. The man also sexually assaulted the 16-month-old, ripping her apart until she died. I don't give you these facts to shock or repulse you. I do it because that is the reality. It is a reality that I personally face several times a month. 2 years ago, I outlined the major changes our office had already made in death penalty cases. One of the new approaches I mentioned was our Capital Case Review Committee. During the sessions of the Capital Case Review Committee, the top criminal bureau supervisors in our office and I carefully review the facts and evidence in each case that's eligible for capital punishment. We then discuss whether it's appropriate to actually seek the death penalty. The facts are always tragic and heartbreaking, and sometimes they're so cruel and so inhuman that justice calls out for the ultimate penalty. We are all human beings trying to live together. We value each other, and some do things so horrible to innocent people that I believe that we as a community can and should say they no longer have the right to be among us. There is no more serious or sober decision that we make, and that is why I chair each of these meetings, and that is why I make the final decision in every case. I have vowed to myself and to the people of Cook County that we will do all in our power to make sure that no future death penalty case will be carelessly flawed as some may have been in the past. We must aim for true justice. We must strive to reach a level of moral certainty. And as long as that responsibility falls to me, we will accept nothing less. We will, as I said, both from our office and as the State's Attorneys Association, cooperate fully with the legislature to attempt to find the path that will allow us to move forward in a responsible way, to take into account the problems that have been identified, but also to examine and deal with the real-life problems that police, prosecutors, courts all have to do in order to find people who are truly accountable and to hold them accountable. If we keep our focus on this being an opportunity to make the best justice system possible, one that will hold the right people accountable with due process of law, I believe that we can all work together and that we will be successful. We pledge to do our part. Thank you very much.
We will take questions from City Club members and guests. Mr. Devine said that he'll have some press availability after the meeting. So if you are a member of the media and you want to ask a question, you'll have your chance when the meeting is over. So City Club members and their guests, step up to the microphone over there. We have a couple of people while you're doing that, Jay, I'm skipping over. We have former State Senator Jeremiah Joyce. Jeremiah, raise your hand. And we also have just close to being alderman, John McCaffrey. Yeah, you got John. You know, you win, you lose, you're part of the game. That's part of the City Club. Yeah, state your name and your question.
Jeff Berkowitz, host and producer of Public Affairs. State's Attorney Devine, I would imagine the members of the Governor's Commission on Capital Punishment were aware of the instances you cited of certain people who have been found guilty and are sitting on death row, and in your view apparently should be sitting on death row and should be executed. I'm assuming they're aware of those circumstances, and yet they obviously carved out of those people who commit such acts, carved them out of the eligibility for the death penalty. So the question for you is, was this commission trying to have sort of a backdoor movement to abolish the death penalty by sharply limiting the eligibility factors to 5?
Well, you're probably asking the wrong person. You should ask the members of the commission if that was their objective. Let me say that this is a good question in the sense that we have to emphasize that the process we are involved in is to make the death penalty process one that is fair, one that holds accountable the right people, one that leads to convictions of people when 15, 16, 17 years from now, when the last habeas corpus petition has been heard or the U.S. Supreme Court denies certiorari, the public and those in the system can look around and say, this is the person that is accountable. The evidence is there to show it. We owe that as members of the criminal justice system to do that. But I am concerned, as the questioner implied, that with some people, the question of how to make the process better gets tied up with their views that there should not be a death penalty. As I said before, we don't have the death penalty because a prosecutor from Cook or DuPage or McHenry or Champaign County says, I want to have it. It's the law of the state of Illinois. And it is our obligation to enforce the law and to do it in the right way. So if people are truly against the death penalty, and there are reasons, there are valid and good reasons why people take that view. I don't quarrel with that. But that debate should be taking place in Springfield with our legislators who decide whether or not we will have that law on the books, or if there are constitutional arguments in our court system. I think it can do some harm to those who are to the process of trying to make the best death penalty process system possible if in fact the motivation of some is to have a system that either can't work or won't work and then just throw up the hands and say, well, obviously it can't work. We have to try and make it work. That's our responsibility.
Any more questions? Yes, Joe, you can speak. Speak loud.
Sort of pinned in there, I have laryngitis, so maybe Paul, you'll translate for me. Joe Cohen, CEO of Richard Hoffman Corporation. If you know, many of us, particularly in this room, were hopeful that you would join the Democratic Prime Minister governor.
I don't think everybody in the room was, but I know my wife wasn't, so.
Yeah, I'm not sure I said everything.
No.
But what are your reflections at this point?
What are my reflections? The question is that there was a huge hue and cry for me to join the gubernatorial race. I think that's, no, there were a number of people who were kind enough to approach me about thinking about the governor's race, and I did think about it. I decided not to do it. And my reflections now are that that's fine. As you know, some of you know, I went through a little procedure a couple of months ago, and that makes you pause and reflect on what's important. I truly enjoy being state's attorney. I think you can tell from the times that I've been before this group that I care about the issues that are involved in prosecution. I think it's absolutely important that a prosecutor not be one who is just interested in racking up numbers, that we look for ways to deal with our juvenile justice problem, our narcotics problem, that really help society get better, help people get better, help the community get better. And I really believe that as much as any office that I can think of, the state's attorney's office has a direct impact on the lives of people. So I'm very happy with the job that I have. And as I say, after my, my little plumbing situation of a couple of months ago, you put things into priorities. We have 2 weddings this year. We have a new grandchild coming. I have a great family, and I'm blessed many times over. So I'm nothing but happy with my life.
That's a very good answer, and a lot of the people in this room really appreciate it, but the bottom line was he just didn't think the name Devine would sell downstate.
Yeah, right. You have a question over here.
Just, I figure Holland would catch that one. Yes, Mr. Bauer, yes, sir.
Mr. State's Attorney, on a federal level, I believe it's Senator Feinstein of California has introduced a constitutional amendment of victims of crime victims, a rights amendment
Right.
to the Constitution. Have you ever had a chance to look at this, and do you have any perspective on it?
Yes, as Mike Bauer's point was that in the national level, we have I think Senator Feinstein from California talking about a crime victim rights amendment. I'm happy to say that in Illinois, crime victims do have a number of rights that have been passed into law. They now have the right to stand up at sentencing and to talk about the impact on their lives or the lives of their family if someone has been murdered or sexually attacked or whatever horrible thing might have happened to them. We recently supported and received an expansion of that so that now a representative of the community can stand up. And we recently had that happen out in the 11th District where Mr. Moore from the 11th District stood up and talked about the devastating impact that one of the major drug rings had had on his community. He was able to tell about children trying to get to school, adults trying to get to church, people trying to use the park and having to go past the drug purveyors as they were dominating the community. So Illinois is an example of a state that really does give some rights to victims. And let me say while I'm talking about that, we represent the community as prosecutors, we represent the people, but in a very special way, we represent the victims of crime. We see, not as direct as the police do, but pretty directly, what families go through when they lose a loved one. So perhaps that's why we come at some of these issues in a little different way from someone else. And I've talked about this a lot. I always talk about the victims. We can never do enough for them. And they are some of the heroes of our world. You know, we easily throw out that term, but there are some great heroes out there. And one of them is a young lady named Shatoya Curry, who was brutally raped and assaulted at Cabrini Green, left blind, unable to speak, paralyzed from her neck down. She testified in one of the big courtrooms out at 26th Street by blinking her eyes, and she helped convict Patrick Sykes, who was responsible for that. This young girl is now, I think, 13, 14? 15? She's 15 now. She's going to school. She has a great outlook on life. She has a wonderful personality. She laughs. She has a laugh that will fill the room. Our opportunity, my opportunity to meet her, and Bill O'Brien and Anita Alvarez, who represented the people in that case and got very close to Shatoya, we know what it means to see heroes, and she is one of them.
Any other questions? Yes.
I have a question.
Your name, please, stand up.
Hi, Cynthia Coble.
Cynthia.
With the Kenneth and Carl Montgomery Foundation
Yeah.
Director, and we've been sending quite a few men coming out of prison to the West Side down next to study computer technology. We've had wonderful returns from that. 57% of the men have graduated, 13% have gone on to higher education, and there's been 6% recidivism rate. What are we going to do about educating people in prison? Because what we're finding is that coming to the North Lawndale area, about 34% of people coming out of prison are coming to North Lawndale, which is causing a huge problem in our city. And I think that when we start talking about, rights of victims, that's very, very important. But when we talk about the rights of children who have gone to prison at age 15 and have served with such mandatory sentencing, 6 to 8 years, we have a responsibility to those children as well. And what can the government do about that and the state Supreme Court?
Well, the question is, what can we do about individuals coming out of the prison system so that they have appropriate opportunities for education and to get into a life that is productive? Our major part of that, frankly, comes at the front end. And what we have tried to do both at the juvenile level and especially with narcotics is find treatment and diversion programs that allow, and it's now up into the thousands, of people to not enter the prison system in the first place, where if they're involved simply in possession of drugs, not involved in violent crime or drug dealing, they have a chance to get involved in a treatment program, and if they successfully complete it, they do not enter the criminal justice system at all. And we're doing some of the same thing at the juvenile level, where young people are involved, but we try and resolve their situation out in the community rather than through the court system, through community mediation. An example of that would be if someone paints graffitis a garage. We might take that out to the community where the offender has an opportunity to speak, the victim, and we have a community mediator come up with a punishment in the community to show the accountability and yet not have this go through the prison system or the juvenile delinquency system. Thousands of young people, and the statistics show this, have been diverted out of the juvenile delinquency system because of that. Additional thousands have been diverted out of the narcotics system and into treatment for that same purpose. So that's what we try and emphasize. Certainly I support, as a general matter, and we all should support programs that allow for people to transition out of the prison system in a way that will give them some skills so they can be a positive part of the community. That should be part of any commitment of a community to do that for people who want to take advantage of it. We also find, and we have just talked about this yesterday, so many people in the prison system have mental health problems that they have to deal with. We don't have enough resources. It's not a year when it appears to me that we're adding to those resources, we're taking away from them, and I think we all as citizens should be very aware of what is happening in Springfield and make our views known on what the priorities should be.
Okay, seeing no more questions, let's give a big round of applause to Secretary Devine.